The Supreme Court has deferred delivering its ruling on the applications by researcher Dr. Amanda Odoi and broadcast journalist and lawyer Richard Delaskai seeking to injunct the transmission of the anti-gay bill to the president. According to the court, the ruling will be delivered when the judgment in the substantive case is being delivered. There is more in this report.
The court came to this determination after concluding that the issues raised in the application for the injunction have a link with the substantive case. Richard Delaskai and Dr. Amanda Odoi filed separate applications asking the Supreme Court to stop Parliament from transmitting the Anti-LGBTQ Bill to the President until a final determination of the substantive cases. In arguing for the injunction, lawyers of the two applicants noted that the approval processes for the bill, on face value, breached Article 108 of the 1992 Constitution. They contended that Article 108 of the 1992 Constitution requires the Speaker of Parliament to deliver an opinion as to whether a bill which is not presented by the executive for approval poses a financial cost on the consolidated fund. It is their view that this opinion was not offered and thus taints the entire proceedings. The Attorney General further submitted that even though all constitutions promulgated in Ghana since 1957 made room for similar provisions, this is the first time Ghana is having to operationalize them following the passage of the Private Members Act in the 7th Parliament. Lawyers for the Speaker of Parliament, however, denied claims that the said opinion was not offered. Thaddeus Sori, who led them, argued that the said breach, even if true, can be remedied after the bill is transmitted to the President. The panel, presided by Chief Justice Gertrude Isaba Tokonu, however, noted that it is better to determine the injunction together with the substantive cases. The court has thus decided to make its ruling on the injunction known after the hearing of the substantive cases.
Our decision is to reserve our verdict on the interlocutory application until the final determination of the substantive suit, at which point we will render a comprehensive judgment that addresses all aspects of the case, including the current application for injunction. In conclusion, the decision of this court on this application for an interlocutory injunction is hereby deferred to abide the outcome of the determination of the substantive suit.
In furtherance of this, the Supreme Court intends to hold an early trial. But what does the court mean by an early trial? Lawyer for Richard Delaskai provides some insights.
When the court speaks about an early trial, in effect what it means is that it will speed up the process towards the determination of the matter so that this whole issue of injunction before final determination will no longer take a center stage.
What then happens to the bill at this moment?
Although it has not expressly been stated granted or not granted, but once it is paid, we don't do anything to prejudice the outcome of the application. So we say that invariably, indirectly, it is still restraining any party from doing anything contrary to the demands of the application.
Meanwhile, the Attorney General is hopeful that the cases will address significant constitutional questions that have not been determined by the courts before.
There are a lot of bills being churned through Parliament now on account of private members, which really have implications for the public purse. And I think for me, as the Attorney General of the Republic, is a question of important consideration that the court ought to really consider.
The case has been adjourned, Senator. The parties are expected to file the relevant processes. The court will then assemble to hear the substantive case. Reporting for ChannelOne News, Hansen Ajiman.